There's a House of Commons library document published June 2025 that every royal commentator missed, and the single sentence on page 4 dismantles the entire William will strip the title story. The sentence reads, "An Act of Parliament is required to remove a peerage once conferred." That's not a legal blog. That's not a tabloid. That's the official parliamentary research briefing MPs use to brief themselves. And what it means is this. The title on the Netflix deal. The title Meghan called her family name on camera. The title that built a $100 million commercial empire. William cannot remove it alone. He needs Parliament, a public debate, a vote. Every MP in the building gets a say. The Penstroke plan has a wall in it. And there's a second document. Same briefing, different page. It cites a Beak report from April 2025. And what it says about an agreement the Sussexes made in January 2020 is something no one has run as a story. Meghan to leave royal duties. It was agreed with Queen Elizabeth that they will not use the HR title. That is a long-standing precedent, and there's good reason for it. Basically, the HR is only given to working royals and senior members of the royal family, because it denotes a level of respect in the public. And also, it's not a financial thing. Working royals do not profit. They do not use their names to make money. It's an honor to have an HR. Absolutely. So the fact that she's continued to use this HR when they've been instructed not to, I think is absolutely infuriating in Buckingham Palace. And there was a very interesting source inside, close to the Prince of Wales, who spoke to the Daily Beast. He said that William is furious, unsurprisingly, and he's also already formulating plans to deal with this when he becomes monarch. By the end of this video, you'll know exactly what that agreement was, exactly what the Beak found, and exactly why the constitutional barrier protecting the Sussex brand is also the mechanism that makes dismantling it the most public royal event in decades. William can't do this quietly. The law won't let him. Why? Now, to understand why this moment is different from every previous chapter of this story, you need to understand one man's track record. Tom Bower has written 27 books. He has never lost a Lyell case. Not once. 27 books about some of the most powerful litigious people in Britain. And not one of them has successfully taken him down in court. Think about that. Robert Maxwell, the media tycoon, the newspaper proprietor. While Maxwell was still alive, Bower documented a pattern of alleged financial wrongdoing. Maxwell filed a legal suit against Bower. The suit lapsed. In 1991, Maxwell died, and investigators confirmed he'd embezzled approximately £440 million from his own employees' pension funds. Bower had it right. The subject just hadn't been caught yet. Mohammed Al-Fed Bower published an unauthorized biography. Legal threats followed. No successful claim materialized. Years later, the BBC and Channel 4 independently investigated Alpha and confirmed the exact pattern of behavior Bower had already documented. Geoffrey Robinson, Labour MP. Bower's 2001 book provided evidence Robinson had solicited a business contract from Maxwell. Robinson was subsequently suspended from Parliament for 3 weeks. See the pattern? Every subject who was loudest in their denials ended up being the one history confirmed. And the tell every single time was what they didn't do. They threatened, they blustered, they didn't go to court. Now look at Bower's 2026 book. Betrayal sourced to serving and former senior palace aides lawyered to within an inch of its life. Published, not retracted, not sued over, and it contains this. William was taking no prisoners. Once he was crowned as king, his brother might well show no mercy to him. And Meghan, the Sussexes haven't sued Tom Sykes, published his Bonfire of Royal Titles column in the Daily Beast in November 2024. Neither their palace issued a denial. It ran without correction. Sykes wasn't pulled, wasn't sued. Andrew Looney went on News Nation and said on the record that William would get rid of Harry as well, and nobody touched him legally either. In the Bower pattern, silence from the subject is data. It means the claims either can't be challenged, or that challenging them would require arguing it under oath in a courtroom. The Sussexes haven't made that move. And here's what makes right now genuinely different. In October 2025, Charles actually used the mechanism on the most senior member of the family it could possibly be tested on. And in doing so, he revealed exactly where it stops working. Those limits, which nobody in the commentary space is discussing, are precisely where this gets legally dangerous. Revelation 1. What the Andrew President actually proved, and what it definitionally cannot. On the 3rd of November 2025, letters patent were issued under the Great Seal of the Realm. The London Gazette published the notice 2 days later. Exact language. The King has been pleased by letters patent under the Great Seal of the Realm, dated 3 November 2025, to declare that Andrew Mountbatten Windsor shall no longer be entitled to hold and enjoy the style, title, or attribute of Royal Highnesses, and the titular dignity of princes. William will strip Prince Andrew along with all other non-working royals of their HRs and princely titles when he ascends to the throne. Meghan and Harry will see their dukedoms and hes formally revoked according to the Daily Beast by Prince William. Read it carefully. Royal Highness Prince. Those two things went by letters patent. The royal prerogative. A pen stroke. Done. But here's what that same document did not do. Andrew remained in the line of succession. That requires an act of Parliament across every Commonwealth realm to change. Andrew remained constitutionally in the Councillors of State pool. The people who can deputize for the King, the UK Constitution Unit, that's the constitutional research body at University College London. Confirmed in November 2025. Removing him from that role would certainly require legislation. A separate royal warrant was then issued, directing the Lord Chancellor to remove Andrew from the role of the peerage, and constitutional lawyers immediately flagged what the government already knew. Any formal bill to accomplish this would be open to hostile amendment. The Star government in the UK Constitution Unit's own published analysis was keen to avoid legislation. So the pen stroke did half the job. Parliament has to finish the rest in public. That's a critical gap, but it's not the biggest one. The biggest one is about the specific title Harry holds. And this is where it gets commercially uncomfortable. Revelation 2, the three-tier reality every biographer missed. I know what you're thinking, but they stripped Andrew. The mechanism works. What's the problem? Here's the problem. Harry holds three legally distinct things. The H-style, the Prince dignity, and the Dukedom of Sussex, a hereditary peerage. And those are three completely different legal instruments, with three completely different removal mechanisms. The House of Commons Library published Research Briefing, CBPE 10370, in June 2025. Not a tabloid, an official parliamentary document. MPs use it to brief themselves. Exact finding an Act of Parliament is required to remove a peerage once conferred. The Middle Temple magazine, a publication of one of England's 4 Inns of Court, the professional body for barristers, published a constitutional law analysis on exactly this question. Conclusion. The universal view is that it is not possible to do this, and a peer can be removed only by Act of Parliament. Now look at where the commercial brand lives. Every Netflix press release, the Duke and Duchess of Sussex. Every headline from the Duke Un 000 2022 docu-series, The Duke and Duchess of Sussex. The brand identity is the dukedom, not the her, not the prince, the dukedom. And the dictum requires Parliament, total silence. Bauer, Sykes, and Looney are solid sources. Their palace access is real. Their reporting on William's intention is almost certainly accurate. But intention and constitutional mechanism are two completely different things. A future King William can intend to strip the Sussex dukedom by letters patent. What he can't do is actually pull it off without going to Parliament in public on the record, with every available amendment attached by every interested MP in the building. The plan has a wall in it, and the biographers didn't see it. That's the major problem, but it's not the biggest one. The biggest one involves a specific BBC report, a parliamentary document, and a promise made in 2020 that the record suggests wasn't kept. Revelation 3, the House of Commons document nobody's quoting. Stick with me on this one, because what we're covering in 5 minutes, the financial and legal fallout only lands once you've seen this piece. January 2020. The Brexit negotiations conclude. Buckingham Palace issues a formal statement. The Duke and Duchess of Sussex will not use their HR titles as they're no longer working members of the royal family. That's not a vague understanding. That's a stated condition of departure. Written down, published by the palace. Part of the deal. I just had this conversation about Harry and Meghan. I was talking to Fox News, and I said they might not think the rules apply to them, but they are insisting on using titles from the British royal family. And when you do that, whether you like it or not, you are representing the monarchy, and there are some rules that you have to abide by. Now look at what House of Commons Library Research Briefing CBP 10370 says, published June 2025. Exact line. The Beck reported in April 2025 that hair was still being used by the Sussexes in a private capacity. They were using Hirsch privately in April 2025, 5 years after agreeing in a formal palace statement not to still using her in private in 2025. But the palace statement from January 2020 says, I'll let you finish that sentence. And here's the constitutional wrinkle that makes this even sharper. The same House of Commons library briefing explains that when a royal agrees not to use an Hirsch, there's no formal deprivation. The title nevertheless continues to be possessed. The agreement is voluntary, not legal. So, the Sussexes technically still have hair. They agreed not to use it. And according to the BBC, 5 years later, they were a future king who strips hair by letters patent would be doing something the Sussexes can't legally protest, because hair genuinely can go by prerogative. But the Duke requires Parliament, and Parliament is public. Which brings us to a Netflix show, an actress named Mindy Kaling, and one sentence that ran into a 65-year-old royal declaration. Revelation 4, the family name that isn't one. Season 1 of With Love, Meghan, Netflix, March 2025. Meghan corrects actress Mindy Kaling on camera. Documented in IB Times UK reporting, June 2025. She says, "It just means so much to go. This is our family name. Our little family name." She's talking about Sussex. Sussex isn't their family name. Sussex is the territorial designation of a doctor. It's a dignity title. In constitutional property law, it's classified as an incorporeal hereditament, a form of intangible inherited property. It's not a surname. It can't legally function as a surname. The 1960 declaration by Queen Elizabeth II established the rule. Descendants of the royal family who don't hold the style or title of Royal Highness, and for whom a surname is therefore necessary, use the surname Mountbatten-Windsor, not Sussex. Mountbatten-Windsor. This is cited in the House of Commons library briefing. It's the same legal basis behind why Sussex Royal had to be abandoned as a brand name in February 2020, when the palace specifically told them they couldn't use it. So, we're not inventing this. The rule existed. They ran into it in 2020, and 5 years later, on a Netflix show watched by millions, the brand statement was that Sussex is the family name. The story evolved. The law didn't. The commercial brand is built on a word that's simultaneously a legal dignity under threat and a name the family doesn't technically own as a surname. And it lives in the exact category that requires Parliament to remove, which is, as it happens, exactly what makes Revelation 5 the one you came here for. Revelation 5. The money is already moving. Let me put the full commercial timeline in front of you because the pattern only makes sense when you see it as a sequence. September 2020. Exclusive Netflix deal. $100 million. 5 years. All marketing built on the Duke and Duchess of Sussex. July 2019. The entity Sussex Royal, the foundation of the Duke and Duchess of Sussex, registered in England and Wales. February 2020. Palace tells them they can't use Sussex Royal. The entity is dissolved. The brand pivots to Archwell. 2021-2023. Spotify deal reported at $25 million. Ended after one season of Meghan's Archetypes podcast. One of Spotify's executives called them grifters. Revenue stream closed. August 2025. Netflix renews. But look at how Forbes described it. The new deal comes with less commitment from Netflix. The New York Times reported it's worth less than the original. Prince William to change the monarchy forever. No titles for Beatrice or Eugenie. And she writes, Prince William is gearing up to become king sooner rather than later, I'm told. And his vision for the monarchy is going to look very different from his father, King Charles's reign. She goes on. Fewer titles mean there is less of a chance for a degenerate like Prince Andrew, now called Andrew at Mountbatten and Windsor, to slip through, which means, as I previously reported, Harry and Meghan will lose their titles, as well as Princesses Beatrice and Eugenie. And here's what got buried in that announcement. The August 2025 deal explicitly folds as ever Meghan's lifestyle brand into the Netflix partnership scope. Her exact words, she and Harry are proud to extend our partnership with Netflix and expand our work together to include the As Ever brand. What's As Ever? It's a deliberately non-royal brand name. No Sussex in it, no Prince, no the Jam. The Rose. The lifestyle content completely title agnostic, built to survive a title strip. The Sussexes didn't rebrand accidentally. Every pivot Sussex Royal to Arwell, Arkawell Foundation to Arrowell Philanthropies, in December 2025, now as ever, has moved the commercial infrastructure one step further from a title-dependent identity. They see it coming. Whether the audience that showed up for the Dukedom follows them to a jam brand is the question nobody's answered yet. I want to step back from the constitutional analysis for a moment, because there's a part of this story the parliamentary documents can't fully reach. Tom Bower's betrayal sourced to Palace Insiders published 2026, not retracted, not challenged in court, contains one line that hasn't made a single front page. William may strip Archie and Leet of their titles as well. Archie Harrison is 7 years old, Leet Diana is 5. The titles they hold, Prince and Princess, were conferred when King Charles acceded in September 22, activating letters patent from 2012 that extended the designation to great-grandchildren of the monarch. Those styles can be withdrawn by letters patent without Parliament, without the children's consent, without any legal mechanism for appeal. They were born into this. They didn't choose it. The 2022 docuseries, that's still 3 years later drawing 7.3 million viewing hours every 6 months on Netflix, is built around what it costs to be in this family, around grief, around what Harry describes as the price of proximity to the institution. The documented plans sourced through Bower, cross-referenced by Sykes, confirmed as intention by Looney, extends the institutional consequences to the generation that follows. On a national radio show reaching 4.3 million listeners, their uncle named his own 3 children by name. George, boarding at school. Charlotte, obsessed with Taylor Swift. Louis, leaving jam fingerprints in the back of the car. He named his wife. He named his grandmother. He named one absent person. Archie Leet, not spoken. The biographers told us what that silence means. The constitutional record tells us what it'll cost to act on it, and the 2 children at the center of it have no vote in any of it. Let's put the numbers in one place. Tom Bower's betrayal sources the minimum annual cost of running the Sussex household at $3 million. Security, staff, nanny, PR, management, property. A May 2026 report from Royal Observer citing page 6 puts the full figure, including mortgage payments on their $15 million Montecito estate, at approximately $6 million a year. Now look at the income side. The Spotify deal is gone. The $100 million exclusivity agreement expired September 2025. The replacement first look deal is worth less. Season 1 of With Love, Meghan, promoted with the full weight of the Sussex royal identity, ranked 389th on Netflix's most watched list for the first half of 2025. 389th. There's a gap between $6 million out and 389th in. And in that gap is where a title functions as collateral, as the thing keeping the premium valuation alive. Here's the legal framework nobody's building correctly. The commercial value of the Sussex brand rests on one specific differential: the gap between celebrity production company and production company run by a duke and duchess. That differential justified the $100 million valuation in 2020. Strip HCH and Prince, both of which can go by letters patent, and that differential collapses, even if the Dukedom technically survives, because the public doesn't parse constitutional distinctions. They see ex-royals, and the premium evaporates. But strip the Dukedom, which requires Parliament. That's a completely different event. The House of Commons Library confirms any parliamentary bill for this would be open to hostile amendment. The UK Constitution Unit warns the government is keen to avoid legislation because it opens debates on wider royal finances. The Spectator put it plainly. In October 2025, government and opposition would both need to agree, since a divided vote on the composition of the royal family would itself breach constitutional convention. Look at the trap. The plan requires silence. The Constitution requires noise. And the moment William goes to Parliament, he hands the Sussexes something 3 biographers and £100 million deal never gave them. The floor of the House of Commons, every day of parliamentary debate, a news cycle, every amendment in committee a headline, every vote covered by every royal correspondent in Britain. Simulcast to every Ariel subscriber on the planet. The constitutional barrier that protects the Sussex brand is also the mechanism that would make dismantling it the most public royal event in decades. William can't do this quietly. The law won't let him. Here's the verdict. The biographers are right about the intention. They're wrong about the mechanism. William can strip HCH from Harry by letters patent. He can strip the prince dignity. He can do both on day one of his reign, with one document under the Great Seal. But Duke of Sussex, the 3 words on every Netflix press release, every as ever launched story, every headline this family's generated since 2018, those 3 words require an act of Parliament to remove. And that act requires debate. And debate is public. No getting around it. The corporate architecture is already migrating away from the royal identity, as ever has no Sussex in it. Our Ruel Philanthropies has no Sussex in it. The commercial entities are being built to survive what's coming. But here's what can't be restructured. The audience's reason for watching. The 7.3 million hours, the 2022 docu-series, still pulls every 6 months, isn't an as-ever audience. It's a royal audience. The moment that royal identity is partially stripped by pen, and fully stripped only by a parliament that debates in public, that audience doesn't follow the jam brand. They follow the drama. And by that point, the drama is in Westminster, not Monteito. Tom Bower, 27 books, never lost a leal case. The Sussexes haven't sued over betrayal. The palace didn't deny the Sykes column. The constitutional law is in the House of Commons Library, publicly available for anyone who bothers to look. And by April 2025, according to the BBC, cited in an official parliamentary research document, the HRE the Sussexes agreed to stop using in January 2020, still being used privately. The title is a brand. The brand is collateral, and collateral only holds its value as long as no one calls the debt. Here's the specific question I want in the comments. Not who's right, not do you like Meghan. Those conversations are everywhere and they go nowhere. This one. If stripping the Dukedom of Sussex requires an act of Parliament, open amendments, public debate, every MP with a microphone, what does William do when someone proposes stripping Archie and Lilette's titles in the same session? Does he pass it? Does he block it? And if he blocks it, what does that silence say about whether any of this was ever really about protecting the institution? Drop your answer. I read every single one. Hit the like button if this channel gave you something the others didn't. The documents, not the drama. Subscribe because the next video is the one nobody's prepared for. The Councillors of State Act 2022. The statute Parliament passed. That means a future King William cannot remove Harry's constitutional right to deputize for the crown without going back to the same Parliament he's trying to avoid. That video drops this week.